I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended.
Imagine being caught in a legal loop where the system says you're guilty, even if you're actually innocent. Today, we're diving into a high-stakes courtroom showdown where a defendant, Mr. Blade, tries to argue that a past mistake by the county shouldn't ruin his life today. But there's a massive catch. The judge's hands are legally tied. Is this a case of a broken system or a driver who just won't follow the rules? Stay tuned, because this legal technicality is about to get intense.
So we've got 2 DWS files, correct?
Over another who's in warrant status, but I think we're here on this motion hearing.
Yeah, so one file's a money issue. The old one from December 2016, that's a drove while license suspended. The file shows you owe money.
Yes.
Right, all right. So we'll talk about that one. All right, and then you filed a motion on the case from November of 2025, correct? All right, give me a minute to look at the paperwork. Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already. So I'm going to read the people's response. Okay, I've had a chance to review. So anything you want to add to your written brief?
It's showing that there was no personal jurisdiction in the court lacked the authority to make a judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lacked jurisdiction.
Now, this is where things get complicated. Mr. Blade is bringing up the Monroe case, arguing that the court lacked personal jurisdiction. In legal terms, jurisdiction is the court's power to hear a case. If a court didn't have the authority to suspend him back then, he feels he shouldn't be penalized for it now. It's a classic fruit of the poisonous tree argument. If the original suspension was invalid, everything following it should be too, right? However, you're going to see the judge explain a hard truth. One court usually cannot just delete what another court did years ago. Watch how Blade tries to explain his trip to the sheriff's office to find the truth.
To make that case for that judgment or
Anything else?
I can't find them anywhere between service and collective. I saw people service from Percival.
Just to be clear for the record, we're still talking about the Monroe case.
Yes.
Okay, go ahead. Right, right.
We two asked for proof of service that were unable to provide it.
Right.
They told me that it was with the sheriff. So I went over to the sheriff's office to ask for proof of service because that service is
Right.
because I never received those to appear in court. So I had no idea that we were charged with it again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from the sheriff's secretary. I'm not sure that they were in a position or if she's at running the test. But she noticed that the ticket had the officer's name, which happened to be down currently the defendant. He come out and spoke to me. He said, I don't remember this ticket. I don't even believe I was I don't even believe I was on that shift at this time. A few things that he mentioned to me. So I wasn't.
Can you believe this? Mr. Blade claims he went to the source, and the officer involved doesn't even remember writing the ticket. This is a dramatic moment because it highlights the chaotic nature of old records. Blade is essentially arguing that he's been living under a phantom suspension. He's pleading for fairness, stating he isn't asking for favors, just the truth. But in a courtroom, the truth has to be backed by paperwork, and right now, the Secretary of State's computer says he's suspended. Question for you. If an officer tells you they don't remember the crime, should the case be dropped immediately? Let me know in the comments.
Prepared for this I was sure everything was supposed to be correct. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an application.
Right.
You know, the things he said, I'm not asking him for anything in my favor, just what you recall, all I want. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response in time to go to the court. But he went to my motion. The officer said he believes that I did have insurance, but I was pretty sure force. Having in notification of the court to be there, nothing. It's prison charges.
Okay. Anything else? Anything to add to your written response that I just read?
No, yeah, the court is well aware that this court doesn't have any jurisdiction over a no proof of insurance citation that was issued by Monroe County Sheriff's Department in 2005.
All right. Mr. Blade, I've got a question for you. Do you know whether or not the Michigan Secretary of State listed you as a valid driver on November 29, 2025?
No, that's not good.
Okay. So if I told you the Secretary of State record showed you were suspended on the day that Officer Hayden stopped you, you would have no reason to take issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case.
One more time.
No, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct? Okay. All right. So I'm going to deny your motion for two reasons.
The judge just laid down the law, and it's a tough pill to swallow. He's denying the motion based on a strict legal hierarchy. In Michigan, the judge's authority is limited to the ticket in front of him. Even if Monroe County made a mistake in 2005, the Secretary of State still officially listed Blade as suspended. Legally, you are required to follow the status on your record until it's cleared. It's a frustrating cycle. Blade is trying to fight the root cause, but the judge is only allowed to look at the current symptoms. It feels like a catch-22, doesn't it? He's being told his Heron Township ticket is valid regardless of whether the original reason was a mistake.
Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking, but I'm only asking you to recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
Gather your thoughts. I'm not in any hurry. These kids want a show.
default judgment issued without prior notice can be deemed as a violation of the party's right to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this court based on what happened in Monroe?
Monroe is the reason I'm here. So
Absolutely.
we can't separate the two because it's the Monroe charge that got me of driving without.
Right.
That got my life.
Right. I understand that.
I did insurance, which I absolutely did. You like to see that?
No. I'll for today's argument, I'll take your word for it.
Did actually have insurance,
Right.
but I didn't have an opportunity to defend, to show the court that I had insurance. So going to jail and then to prison right behind us, when I come home, I'm trying to get my life together.
Okay. Well, first of all, I can't speak from personal knowledge of Monroe.
This is the emotional heart of the case. Blade is explaining that he went to jail and then prison, and now that he's finally home, he's just trying to get his life back on track. This is a reality for many people re-entering society. Old legal ghosts appearing and stopping them from moving forward. The judge admits he can't fix the past, but he offers a small olive branch. He can take this into consideration during sentencing. This highlights a massive gap in our justice system where administrative errors can create a permanent barrier for someone trying to do the right thing.
But every court I know of on a civil infraction, they don't send a notice out on a civil infraction. The ticket is your notice that you've got a problem you got to deal with.
But I didn't receive it. I went to jail that night.
So they never handed you a ticket.
No.
Okay. Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case, as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drove while license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended. Whether or not Monroe screwed up or they didn't screw up, you were suspended. So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation.
The drama shifts from a legal argument to a negotiation. The prosecutor is offering a deal. Plead guilty to the driving while license suspended DWLS charge, and they'll drop the other two misdemeanors. This is a common courtroom tactic. It saves the court time and gives the defendant a lighter sentence. However, Blade is still stuck with the fact that he's pleading guilty to something he feels wasn't his fault to begin with. Would you take the deal to avoid more charges, or would you keep fighting on principle? It's a high-stakes gamble that many defendants face every single day.
And you're,
Okay.
Mr. Blake, if one wishes to plead to the drug license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
Vehicle and another misdemeanor registration title among the two.
Oh, I'm sorry. I was looking for civil infraction. Okay. All right. Do you want to avail yourself of that offer? He will dismiss two misdemeanors if you plead to the drove while license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right? Those two would be dismissed if you plead to the drove while license suspended, revoked, or denied.
See that over?
The hallway is yours. Yeah, go take a minute. That's fine. Why?
Research.
You no objection to another? We'll adjourn it. Oh, I don't care. March 12th, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
But I have any money to pay. I currently don't have any money.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
I think about financing. But I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that.
Okay. How much?
Even if it's just one number.
No, I'm not paying a clerk to process a dollar payment. But I got to get something going. How's this? When's the last time you worked?
I don't know.
Where do you work?
Walmart.
Walmart?
Walmart.
Cormart, what do they do?
They,
Okay, full-time job? Okay, can you pay $50 a month? Start when? First Friday of March is the 6th, and that's 2 weeks out. Can you do that? 50 a month. We'll always take more, so if you want to pay extra. $50 a month, starting March 6th. Yes? Agreed? Okay. We're getting you notice on that other court date. Have a good day.
Yeah.
You're welcome. Officer Haydack, always a pleasure. Be safe.
In the end, this case served as a stark reminder that the wheels of justice turn on documentation, not just intention. While the judge denied the motion to dismiss the case based on jurisdictional issues, he showed a degree of compassion by setting up a manageable 50-a-month payment plan for Blade's $840 debt, recognizing his employment at Walmart. The case was adjourned to March, giving Blade a bit more time to get his affairs in order. It's a bittersweet outcome. He didn't get the total win he wanted, but he avoided immediate disaster. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.